This is in the matter of the people of the state of Michigan versus Gary Shoemate, file number 23-21507FC. I have Jeffrey Bennett appearing on behalf of the defendant, who is present here in person, and I have Jacqueline Weiss appearing on behalf of the people. I have received sentencing memorandums from the defendant as well as response by the prosecutor. I believe it was yesterday. Ms. Miles dropped off a victim impact statement with a request for restitution, which we will address. So, Mr. Shoemate, have you had a chance to meet with your attorney and read and review the pre-sentence report?
No, we reviewed it. We reviewed it over here. No,
right.
We reviewed it in the jail. Oh, we did the first time.
All right. So, Mr. Shoemate, he came to the jail at the original date of sentencing back in May, and he reviewed the pre-sentence report with you. Is that correct? Say it again. Say yes or no.
Yeah.
Okay. And then today you got a chance to speak with him.
Yeah.
All right. And do you need more time to speak with them, or are you satisfied that you've had enough time?
I had enough time to speak with him, but I got a question for you.
Well, why don't you whisper that to Mr. Bennett before you ask me? Okay. Are you satisfied with Mr. Bennett as your attorney and the advice that he has given you?
Yeah.
Yes. Okay.
The answer is no in May.
Is it yes now?
Yeah.
Okay, good. All right, well, first, Ms. Weiss, do you wish to explain or challenge the accuracy or relevancy of any information in the body of the pre-sentence report?
Including the family history portion, Your Honor.
If it's an objection by you or an objection by him, so
yeah,
sure.
I would ask for an addition to the body of the report. Mr. Bennett asked to take off a Lori Went and a Christina Shoemate on information. I believe that they're both deceased. I tried to look into that. I don't have that information.
So,
okay.
All right. So let Mr. Bennett voice his objections.
Okay.
Yeah, I have so many more.
Yeah. So just anything you want to object to.
Okay.
Not what he put in his memo.
Okay. I did attached to my answer to genetic testing to add Tanya Shoemate, T-A-N-I-A Shoemate, as one of Gary Shoemate's biological children, with the mother being Brandy Shoemate, and Jordan Shoemate being the biological son of Gary Shoemate and Brandy Shoemate.
Any objection to that?
Your Honor, the issue was litigated in Hillsdale. He was determined to be the biological father. I don't object to it. However, his parental rights have been terminated in that case down there nowadays.
Okay, so we can add the names as biological father and then add the information as parental rights were terminated.
Thank you.
I believe that would make it accurate.
Okay, Mr. Jones, is that fine?
Sure.
Okay, all right. Anything else on your part?
No, thank you, Your Honor.
Okay, now we'll go to you, and I know that you have quite a few. So let me get that done. All right, so Mr. Bennett, do you wish to explain or challenge the accuracy or relevancy of any information in this report?
I do, Your Honor. On the cover page of the report, it indicates that there's no psychiatric history. However, there is a psychiatric history, as is explained additionally in the report. There's also Mr. Shoemate had disclosed to me an additional suicide attempt, and he was involuntarily committed for psychiatric treatment. So I think the box should be checked. Yes.
Okay, so Mr. Jones, let's let Mr. Jones sit there. We good? Okay, go ahead.
Your Honor, on the section regarding consecutive sentencing, I believe we agree on this. It says that the court may impose consecutive sentence. However, MCL 750.520B3 states that it's only involving the same transaction. As the court's aware, these were 4 separate transactions that resulted in 4 separate convictions. As a result, consecutive sentencing is not permissible.
And the recommendation is for concurrent sentencing. Correct.
Subject to your
right.
Okay. I don't believe that can be done.
Okay.
Your Honor,
And any objection to that?
No.
Okay.
on page 10 of the report, and this is where I was mistaken. Lori Went, the former spouse, is now deceased.
Right, so,
No objection.
so Mr. Jones will mark that as deceased.
And Ashley's last name, Mr. Shumate believes, is now White.
Okay.
I have no information. I have no objection.
Ashley is the last name. White, yeah, it's now White.
Okay, so Mr. Jones will make note of that. Anything else?
Yes, Your Honor, on page 11 of the report, under the physical health section, I would ask that it be modified to state that the cardiac condition is congestive heart failure and atrial fibrillation. Sorry, I'm having a hard time speaking today. The back injury should indicate that it's a deteriorating disc.
So I have in 2018, he was diagnosed with congestive heart failure and COPD. If you look at narrative.
Right. It does not indicate the back injury. He has a deteriorating disc in his neck and back.
Okay, Mr. Jones.
I can change it, but I have back work, I just like to, I don't know.
I guess I was just being more specific, but he also has.
That's fine, Judge.
Okay. Okay, Mr. Jones, or Mr. Bennett.
And in the mental health section on page 11 and the beginning of page 12, the report should indicate that the clinical depression treatment began six years ago. There's a box for that, it's currently empty. The narrative portion should be modified to add that he attempted suicide in 2019 and 2022. And the 2022 suicide attempt resulted in Mr. Shumate being involuntarily committed for treatment.
Judge, this information is taken from the interview that I've done at the PSI.
Okay.
If you wanted to add it, I'll add it, but this is clearly stuff that was not disclosed.
All right, so we can add that just for the benefit of the DOC. All right,
All of that to the body of the report, other than the fact that, as I indicated, and the reason this was adjourned, that the transcript controls the sentencing in this case. As
Right.
opposed to the description of the offense.
okay, so we're gonna move, anything else? And then before I
Not
move
on
on to
the body of the
guidelines?
report.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not by the defense, Your Honor.
Okay,
No, Your Honor.
all right. The probation department in this case scored the guidelines for each count. So I know the objections for the most part cover each one. So on file number 20, or on count 1, criminal sexual conduct first degree, the guidelines on that one were 126 to 210. And the guidelines were the same for count 1, count 2, and count 3. And I think the objections were the same on those 3.
Yes, Your Honor.
Okay, so I'll, and the objections are to OB8 and OB9. So on each one of those, right?
On the counts 1 through 3.
Yes.
Are the objections, yes, are
So,
to
okay.
8 and 9.
So could you please address your objection to OB8?
Yes, Your Honor, and I put this in the report. Position on OB8 on those 3 offenses, and just to be clear, this is not the one with the incident regarding the oral penetration and the other conviction that resulted in 1997. But it's the 3 exclusively with Ms. Miles, that there was no aspiratation, and certainly not on all of them. She testified, I think it was a little inconsistent sometimes. He said he took her there. I think the first time she said that he followed her there. So I don't believe that aspiratation can be scored on those. And additionally, OB9 is scored.
Can we just focus on OB8 first?
Oh,
Okay, so Ms. Weiss,
Your Honor, under OB 8, in People v. Berea, Michigan Supreme Court, nothing in the plain language of the statute requires that the movement of the victim be greater than necessary to commit the sentencing offense. The court heard testimony that the victim and her brother were present in the living room, and Mr. Shoemate would in fact take her from that area into a bathroom to commit assaults 1 through 3. And because of that, she was removed to a location where the sexual assault was less likely to be discovered, which rendered the location a place of greater danger or a situation of greater danger sufficient to score OB 8 at 15 points. I'd ask you to keep that 15 points.
Okay. Anything to add further?
Not to hold.
Okay.
Not to hold.
Well, People v. Berea, 500 Mich 14, 2017 does state, as Ms. Weiss orated. In this case, I do believe OB8 was properly scored at 15 points. These incidents involved the defendant taking the victim to an area where they were most likely to be found or following. So I think the testimony clearly supports OB8 being scored at 15 on these first 3 counts. So address OB9, please.
Yes, Your Honor. OV9 indicates multiple victims. As to counts 1, 2, 3, there was just the one victim, Ms. Miles. The people's response is that there were other people put in place of danger, specifically in her situation, it was the brother. However, this is sexual assault against his daughter, not a son. I don't believe he was a victim in the case. And additionally, if you score OV9 and you're going to score all the counts separately, then OV9 could only be scored in one of the 3 counts. There was testimony that on one incident, the brother was there. There was no testimony that the brother was there on any of the other counts.
Your Honor, again, the testimony, as I recall, was that on most of these occasions when it would occur, her and her brother would be sitting watching cartoons, and Mr. Shoemate would take her from that location into the bathroom. A person may be a victim under OB19 even if he or she OB9, I'm sorry, even if he or she did not suffer actual harm. A close proximity to a physically threatening situation may suffice to count the person as a victim. People v. Gratch, 299 Mich. Ave. 604. There's sufficient testimony at the trial to score OB9 at 10 points.
All right, I do agree with the people on this. The testimony at the trial did support that the brother was in the vicinity when these events occurred. So I will leave OB9 scored at 10 points on count 1, 2, and 3. So count 4, and there were no more objections on those 3 counts. And then count 4, criminal sexual conduct, 4th or 1st degree, was also scored 126 to 210. There was no objection. Well, you were objecting on count 8 on that one. Is that correct?
As to the asportation, yes, not the number of victims.
Okay. So with regard to the asportation, what's your objection under OB8?
It's the same objection that the girls were present. He didn't take them anywhere. Where they came into the room is where these assaults were testified that they occurred to. And so there was no asportation.
Ms. Weiss?
Your Honor, testimony established during the trial that Mr. Shoemate had his daughter go get her 6-year-old friend to bring back to the camper, the trailer, to for the purposes of sexually assaulting them, and took them to a bedroom to accomplish that. So I would again say 15 points is appropriate for asportation.
Based on the information at the trial and the testimony, I do believe that OB8 is properly scored on that one as well, for the reasons stated by Ms. Weiss. All right, so before the court passes sentence, Ms. Weiss, is there anything, I know you said that there is not a victim that wishes to speak today, but is there anything you'd like to say?
Your Honor, reading Mr. Bennett's memo, and I understand advocating for his client, wanting the low end of the guidelines, indicating that his client is in poor health, physically and mentally, and that this occurrence happened in 1997, which was so long ago. I would just indicate to the court again, this did happen in 1997. Mr. Shoemate was subsequently convicted of CSC of a 6-year-old child. And he also went on to father 2 children with his own biological daughter, whether she was of age or not. These are not things that he's doing great since 1997, Your Honor. These are things that show that he has a problem. He also has another charge pending with a victim who was 8 years old at the time, who had suffered significant injuries. That one is charged as a CSC first with a mandatory minimum 25, which again, the reason that the legislator changed the punishment on these type of offenses is because they continue to reoffend. I would ask you to give the maximum to Mr. Shoemate, the 17.5 to 50 years that is recommended by MDOC.
Mr. Bennett, is there anything you'd like to say on behalf of your client?
Yes, Your Honor, and just to, go over, I'm thinking of the punishment and the sentencing rationales, the normal things that you would think the reason you punish people tend to go away as applied to Mr. Shoemate based on the, nearly 30 years, the time that deterrence works, the time that retribution works, are when this stuff happens. And unfortunately, well, he did at the same time, I guess, was convicted of the other case in the one instance in 1997, or not 1998, he was convicted. He is an older person now in 2024, 60 years old. He's in deteriorating physical and mental health. And when you look at incapacitation, regardless of whether it's the 126 or the 210, it's probably a life sentence for him. I think he knows that. But it's being an old case, asking the court to sentence at the bottom of the guidelines in the interest of justice and to properly apply the law to the facts that were testified to at trial.
Mr. Shoemate, is there anything you'd like to say on your own behalf? And make sure to speak loudly into the microphone.
No, I'm just gonna let it go.
Okay. In determining the appropriate sentence in these cases, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentences are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication from law, and the protection of society. While it is true that these incidents occurred a long time ago, it may be a long time ago for you, Mr. Shoemate, but I am going to hazard a guess that the victims in this case have relived this every day of their life since then. It's a sentence of the court that you will, on count 1, serve a period of 17 years, 5 months to 50 years with the Michigan Department of Corrections, with credit for 288 days already served. Or no, what's the update on the credit?
It should be 378 now, Judge.
All right, so 378 days already served. There's a $130 crime victim rights fee and $68 state cost. You are to be on the Michigan Sex Offender Registry for life and electronic monitoring for life. You are to have no contact with the victim AM directly or indirectly. On count 2, it's a sentence of the court that you've served a period of 17 years, 5 months with the Michigan Department of Corrections to 50 years with credit for 378 days already served. And that's with MDOC, $68 in state costs, same requirement to be on Michigan Sex Offender Registry for life and also on electronic monitoring for life and no contact with the victim AM. On count 3, sentence of the court that you will serve 17.5 years to 50 years with the Michigan Department of Corrections with credit for 378 days. $68 in state costs, required to be on the Michigan Sex Offender Registry for life and on electronic monitoring for life, and no contact with AM directly or indirectly. On count 4, it's sent to the court that you will serve 17.5 years to 50 years with the Michigan Department of Corrections, credit for 378 days already served, $68 in state costs, required to be on the Michigan Sex Offender Registry for life and also on electronic monitoring for life, and no contact with the victim, in this case, AM directly or indirectly. And these sentences will run concurrently to each other. Anything to add, Mr. Jones?
Judge, just the restitution.
Oh, I'm sorry. And we did have a discussion in back regarding restitution. Restitution was submitted as proper, but I believe that part of that restitution involved $200 for no-show appointments, and I can't assess that. So I will assess restitution in the amount of $175. Now, anything else, Mr. Jones?
I think that's it.
Ms. Weiss?
I do want to address the other file when you're ready for that. We have a pretrial on today. Got in file 22210076 SC. I would like to set that for a jury trial if Mr. Bennett's ready to do that. And I would like to meet with the victims, and if we are going to dismiss that, we will do that as soon as possible. Otherwise, we will be ready for trial.
All right, so let me finish this one
Okay,
first.
yeah.
So, Mr. Shoemate, my bailiff's gonna hand down to you your advice of rights form. You're gonna initial and date one copy to go back in my file to acknowledge you received the paperwork. The other 2 copies are for you, and if you wish to appeal the sentence, you just need to fill out the paperwork and get it back to us within 42 days. You can, if you want, sit down and fill that out today, and we'll process it today as well. So go ahead and have him do that. And then we will address the pretrial. You're on that file as well, Mr. Bennett. So. All right, yep, you can sit down in a minute, Mr. Shoemate, and do that. Let me just get my copy back, and then you can have a conversation on that, fill it out if you want to do it today before. All right, so then let's move on to file number 23-21076 FC. Again, Mr. Bennett appearing on behalf of the defendant, and I have Jacqueline Weiss appearing on behalf of the people. This is a pretrial conference. So now go ahead, Ms. Weiss.
I apologize, Your Honor. In that file, I would like to it's up to Mr. Bennett, set it for one last pretrial. I'm ready to set it for a trial date. However, that's with the understanding I am meeting with the victim's family based on to talk about this case and see if they wish to still proceed at this time or how they wish to handle that.
Okay, how far out would you like a pretrial?
It's up to Mr. Bennett. I'm okay.
Your Honor, with your permission, actually, I would rather set it for another pretrial. Mr. Shoemate is.
She asked for another pretrial, and I'm asking.
Oh, I'm
how
sorry,
far
I
out
agree
you would
with
like
that.
pretrial. How far out do you want a pretrial?
How far out can I go?
Well, I probably don't have one available for a month.
Okay, is it possible to go in?
Well, he's gonna go to MDOC now, right? So he'll be at intake, so 60 days?
Yeah, that would be great. I have 5 trials coming up in the next 6 weeks.
Okay, so Ms. Adams, could I get a pretrial for mid to late October, please?
All right. Could do October 16th or October 23rd.
October 16 or October 30th, you said, or 29?
23rd, 2-3.
Oh, 16 or 23.
I'm here.
I'm available either day.
All right, let's do October 23rd at 8:30 a.m. Ms. Adams, I'm doing the scheduling order. If you want to come grab it and we'll get them, give me 3 copies so we can get that taken care of. So, sir, if you wish to do the appeal, under a request for attorney, you have to date it, so it'd be August 8th and sign it. Do you see that?
Here where it says recipient notice.
Can you slide over this round? Let me know my right side.
So counsel, we will get a notice to you
Thank you, Your Honor. I'm gonna run down and grab my coffee and I'll be back to the meeting.
for the meeting, okay.
Thank you.
And then Mr. Bennett, you and Mr. Schumate will get a copy for, and then once he fills it out, my bailiff will hand it back to us for me to. Linda, we are done till you hear this afternoon.
We have to record.